Our next defence is the defence of triviality. How does this one work? Have a look again at the Defamation Act of Queensland. Section 33 of that Act says it's a defence to the publication of defamatory matter if the defendant proves that the circumstances of publication were such that the plaintiff was unlikely to sustain any harm. So this is where you look at the full circumstances of the publication of the matter, and the court then needs to consider, is the plaintiff likely to actually have any harm to their reputation? So the case of Barrow and Bolt is an example of this. In this case, Mr. Barrow made complaints about Andrew Bolt, the media commentator, to a regulatory authority. Bolt then wrote a letter back in response to the allegations, because the authority had alerted Bolt to the allegations and asked for a response. Part of that response included things like saying Barrow could have left comments on Bolt's blog and therefore have rebutted information which Barrow was claiming was incorrect. Barrow had complained a number of times previously, and Bolt and his organisation had not changed things, but Barrow could have left comments. They also went on and talked about Barrow being a vexatious litigant and a range of other things. The court said the test is whether those circumstances were such at the time of publication that it was unlikely that the applicant would suffer harm. They looked at the whole of the circumstances. Bolt's letter, while it was forwarded to Barrow, effectively was seen only by a very small range of people at the regulatory authority, authority that was going to be looking at whether or not Bolt had acted improperly. They were not widely disseminated, and in addition, they were understood by everyone involved to have been an attempt to rebut, whether truthfully or otherwise, a complaint made against Bolt by Barrow. The court said in those circumstances, it was unlikely that Barrow would suffer harm to his reputation. Very few people had seen it. Those who had seen it were used to dealing with these types of complaints and to discounting levels of hyperbole in them. That Barrow, the statements about Barrow would be seen in the context of Bolt attempting to defend himself, and that therefore they would be seen as part of an adversarial process and something which had to still be tested for truth. So in all of those circumstances, the court said Barrow had not suffered harm, or it would be unlikely that he would suffer harm. The court went on and looked at, does this term harm only mean harm to reputation? Because in that previous case of Barrow and Bolt, the court had looked at and said in that situation, it's unlikely that it includes harm to emotions, but they didn't have to decide it. So then in the case of Lucht, that argument was made that the harm covered could in fact include harm to emotional state. You might remember the case of Smith and Lucht. I mentioned it in week 3. This is the case which involved an Ipswich solicitor, Mr. Smith. His daughter-in-law, Ms. Smith, who had married his son, had a previous husband, Mr. Lucht. And Mr. Lucht actually had written to the daughter-in-law and son saying that Mr. Smith was Dennis Denuto and was a Dennis Denuto, and referred to him on a number of occasions as being Dennis Denuto, the somewhat incompetent solicitor from the movie The Castle. The Lucht used as one of his defences the defence of triviality, and the Queensland Court of Appeal looked at that defence. They said that harm was not defined under Section 33 of the Defamation Act. But they had to look at the whole of the circumstances of these comments about Dennis Denuto. And they looked at the fact that those comments were being made only to Ms. Smith, who regularly discounted and disliked what Lucht was saying and disliked him rather intensely, and to Mr. Smith's son, who, like his wife, did not place very much weight on anything said by Lucht. So they had to look at, say, is there harm here in all of these circumstances? The court confirmed compensable harm for defamation includes the damage to reputation, and it can include distress and hurt suffered by the plaintiff. That is what you get damages for. But that's not what harm means for this defence. They went on and they said the defence of triviality actually requires the court to focus on the circumstances of the publication of, in that case, the 3 defamatory imputations, calling Mr. Smith Dennis Denuto on a number of occasions. They said there, in all the circumstances where the comment was made only to 2 people who knew Mr. Smith well and knew of his abilities, that were likely to discount anything said by the by the defendant Lucht, who were likely to discard anything said by that source and who disliked him intensely in the context of bitter family law proceedings. They were unlikely to have factored that into their ideas around the reputation of the father and father-in-law that they knew so well. So in those circumstances, they said there wasn't harm to reputation. However, then they said, well, what about the fact that the father-in-law saw these comments and was incensed and upset, was made very upset by the fact that he was being impliedly called incompetent? The court, and in particular Justice Flanagan, had considered this argument that any harm could include emotional upset and harm to feelings. And Justice Flanagan said, I'm of the view that the words any harm in section 33 are confined to reputational harm and do not extend to hurt to feelings. So when you're looking at the defence of triviality, split off ideas around what is compensated and the basis for a remedy, and look just at the circumstances of publication and whether there is harm to reputation. So that's quite a useful case that tells us here in Queensland and has been persuasive around Australia on what harm means. Another example of triviality and what is and is not trivial came up in the case of Wilson and Bauer Media. This is Rebel Wilson's case. In this case, as you'll see in our example, the plaintiffs had made a series of articles which portrayed Ms. Wilson as a serial liar who could not be believed without corroboration, etc. Bauer Media raised a defence of triviality. They argued it's trivial because gossip about celebrities is trivial, in effect. The court said, first the jury outright rejected the defence of triviality. But then the judge went on to consider and talk about it as part of looking at aggravated defences and whether aggravated damages and whether this defence of triviality should have been maintained. To find that it shouldn't have been maintained was part of the circumstances of aggravation. The judge said the sting that Ms. Wilson was a serial liar and could not be believed unless corroborated by external evidence was serious. It was likely to be injurious, and it was understood as such by the defendants prior to the publication. That is not a matter. They then had to look at, well, would that be understood in all the circumstances to have done no harm? The court went on to say the jury found that Ms. Wilson was branded a serial liar. Defences of substantial truth and triviality were rejected by the jury. I reject, as did the jury, the defendant's contention on the seriousness of the implications found by the jury as conveyed was tempered in any significant respect by the light-hearted nature of the articles, or by the notion that for the plaintiff to lie about such things was, given that she was a Hollywood actress, not a serious matter at all. Ms. Wilson's reputation as an authentic, candid and honest, down-to-earth Australian was key to her identity and appeal, and her reputation with moviegoers was central to her capacity to win lead or co-lead acting roles in which she would carry the movie. So the judge is saying that merely saying that your publication is generally non-serious does not mean it is trivial. The question for triviality is, in all the circumstances, does this do harm or no harm to the reputation of the plaintiff? And in the case of Wilson and Bauer, the judge is saying it did, in fact, when you read the case, it was doing substantial harm, and therefore it's not trivial. So that's our defence of triviality. If something is a defamatory imputation published by the defendant about and identifying the plaintiff is, however, trivial, such that it does no harm in all the circumstances to the reputation of the plaintiff, this defence will apply.